Welcome to The Docket. I'm your host, Corey Snow. This is episode 23. On November 16, 2023, the Ethics Committee of the U.S. House of Representatives released a report on allegations relating to Representative George Santos. The Investigative Subcommittee of the full Ethics Committee released a 56-page report, and the Ethics Committee released an 8-page summary. What follows is a narration of the Investigative Subcommittee's full 56-page report. The 8-page summary report was the subject of the docket's 22nd episode. The original document, including all citations and footnotes, is available at a link provided in the show notes. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. Adopted by the Investigative Subcommittee on November 9, 2023, 118th Congress, First Session, U.S. House of Representatives Committee on Ethics, in the matter of allegations relating to Representative George Santos, November 9, 2023. Mr. Joyce from the Investigative Subcommittee submitted the following report to the Committee on Ethics. Committee member list and table of contents omitted from audio version. 1. Introduction. A fundamental tenet of government service is that public office is a public trust. As noted in extensive detail below, the evidence uncovered by the Investigative Subcommittee, ISC, revealed that Representative George Santos cannot be trusted. At nearly every opportunity, he placed his desire for private gain above his duty to uphold the Constitution, federal law, and ethical principles. On February 28, 2023, the Committee on Ethics Committee unanimously voted to impanel an ISC to review whether Representative Santos may have engaged in unlawful activity with respect to his 2022 congressional campaign, failed to properly disclose required information on statements filed with the House, violated federal conflict of interest laws in connection with his role in a firm providing fiduciary services, and/or engaged in sexual misconduct towards an individual seeking employment in his congressional office. In May 2023, the ISC expanded its jurisdiction to review additional allegations that were the subject of a federal indictment filed against Representative Santos in the United States District Court for the Eastern District of New York, EDNY. A superseding indictment was filed on October 10, 2023, charging Representative Santos with a total of 23 counts of criminal activity. The ISC reviewed the allegations underlying those charges, as well as a broader range of alleged misconduct beyond the scope of the indictments. Representative Santos has been the subject of significant public reporting about his many alleged fabrications, including allegations that he has lied about his degrees, his religion, his work experience, his family, and numerous other aspects of his biography. But Representative Santos's lies go far beyond inaccuracies on a resume. The ISC's investigation revealed a complex web of unlawful activity involving Representative Santos's campaign, personal, and business finances. Representative Santos sought to fraudulently exploit every aspect of his House candidacy for his own personal financial profit. He blatantly stole from his campaign. He deceived donors into providing what they thought were contributions to his campaign but were in fact payments for his personal benefit. He reported fictitious loans to his political committees to induce donors and party committees to make further contributions to his campaign, and then diverted more campaign money to himself as purported repayments of those fictitious loans. He used his connections to high-value donors and other political campaigns to obtain additional funds for himself through fraudulent or otherwise questionable business dealings. And he sustained all of this through a constant series of lies to his constituents, donors, and staff about his background and experience. The ISC determined there was substantial evidence that Representative Santos violated federal criminal laws, some of which are the subject of the pending charges filed against him in court. The ISC also found substantial evidence of additional unlawful conduct by Representative Santos, including evidence that he withheld or falsified information on statutorily required disclosures of his campaign and personal finances to the Federal Election Commission, FEC, and the House, respectively, and converted campaign funds to his personal use. Despite Representative Santos's efforts to blame his former treasurer for the numerous campaign finance violations, the ISC's record demonstrates that he was a knowing and active participant in the misconduct. While Representative Santos has claimed, both through counsel before the ISC and to the media, he would fully cooperate with the ISC's review, that was another lie. Throughout this matter, Representative Santos evaded the ISC's straightforward requests for information. The limited responses he did provide included material misstatements that further advanced falsehoods he made during his 2022 campaign. He has also continued to flout his statutory disclosure obligations and failed to provide the American public a timely and truthful accounting of his finances. Based on the unique and unprecedented circumstances in this case, the ISC unanimously determined that the committee's duty to safeguard the integrity of the House and the interests of justice warranted the immediate disclosure of its findings. Pursuant to Committee Rule 19G, the ISC has decided to transmit this report to the committee and not bring specific charges against Representative Santos in order to avoid substantially interfering with the Department of Justice's, DOJ, ongoing and active prosecution of Representative Santos and others for related allegations. The committee has already devoted substantial resources to this matter, and Representative Santos has declined every opportunity to make his case before it. For these reasons, the ISC recommends the committee immediately refer the substantial evidence of potential violations of federal criminal law to the DOJ. The ISC further recommends that the committee adopt this report and publicly condemn Representative Santos for his conduct, which the ISC found to be beneath the dignity of the office and to have brought severe discredit upon the House. 2. Procedural history. A. Establishment of the Investigative Subcommittee. Shortly after the November 2022 general election, news reports raised doubts about claims Representative Santos made during his campaign regarding his education, work, and family history. Questions also arose regarding hundreds of thousands of dollars worth of loans Representative Santos purportedly made to his campaigns, and the accuracy of his financial disclosure, FD, statements filed with the House, which showed a sharp rise in his personal wealth in a short amount of time. Representative Santos publicly acknowledged that he embellished or lied about certain details relating to his background, but denied breaking any laws. On January 10, 2023, Representative Daniel Goldman and Representative Richie Torres sent the committee a letter, offered as a complaint, requesting an investigation into whether Representative Santos failed to file timely, accurate, and complete FD statements and raising questions regarding purported loans he made to his campaign. On February 3, 2023, the committee received a letter from an individual who had applied for a position in Representative Santos's congressional office, in which the individual alleged that Representative Santos sexually harassed him and violated House rules relating to the use of volunteers. In addition, several resolutions have been introduced in the House regarding Representative Santos's alleged conduct. On February 21, 2023, the Office of Congressional Ethics, OCE, notified the committee that it had commenced a preliminary review into allegations that Representative Santos unlawfully omitted or misrepresented required information in his candidate FD statements or FEC candidate committee reports. Representative Santos's campaign committee may have reported expenditures that may not have been made for bona fide campaign or political purposes. Representative Santos's campaign committee may have accepted excessive contributions in the form of personal loans and contributions that may not have been Representative Santos's personal funds, and Representative Santos may have sexually harassed or discriminated against a prospective congressional aide. On February 28, 2023, at its organizational meeting, the committee unanimously voted to impanel an ISC to review whether Representative Santos may have engaged in unlawful activity with respect to his 2022 congressional campaign, failed to properly disclose required information on statements filed with the House, violated federal conflict of interest laws in connection with his role in a firm providing fiduciary services, and/or engaged in sexual misconduct towards an individual seeking employment in his congressional office. On March 1, 2023, the committee notified Representative Santos of the establishment of the ISC and transmitted a copy of the complaint and the resolution setting forth the ISC's jurisdiction. At that time, the committee advised Representative Santos of his right to submit a response within 30 days. On March 31, 2023, Representative Santos's counsel submitted a letter to the committee advising that they did not have sufficient information to provide a comprehensive response to the complaint and that they were working with their client to gather information. However, a substantive response to the complaint was never provided. Under House Rule 11, Clause 3R, and Committee Rule 17A-K, the committee may request the Office of Congressional Ethics cease its review of any matter and refer such a matter to the committee if the committee has an ongoing investigation into the same matter. This process is also outlined in House Resolution 895, which established the Office of Congressional Ethics in 2008 and has been readopted by reference in the current Congress. House Resolution 895, Section 1D1 states, "Notwithstanding any other provision of this section, upon receipt of a written request from the committee that the OCE Board cease its review of any matter and refer such matter to the committee because of the ongoing investigation of such matter by the committee, the Board shall refer such matter to the committee and cease its preliminary or second phase review as applicable of that matter and so notify any individual who is the subject of the review. In any such case, the Board shall send a written report to the committee containing a statement that, upon the request of that committee, the matter is referred to it for its consideration, but not any findings." On March 29, 2023, after the OCE Board notified the committee that it had authorized a second phase review of the matter, the committee requested that OCE cease its review of allegations relating to Representative Santos because of the ISC's ongoing investigation into the matter. Notwithstanding the committee's request and applicable House rules, on May 1, 2023, OCE transmitted a report and findings to the committee. When transmitting the referral, the OCE Board included a letter stating that it considered the committee's cease and refer request approximately 3 weeks after the committee sent the request, at which time the Board voted to truncate its investigation and refer findings to the committee. OCE's continued review of allegations and referral of findings, following a cease and refer request from the committee, was not consistent with House Resolution 895, Section 1D1, or OCE's own Procedural Rule 12A. Because OCE was explicitly prohibited from transmitting findings to the committee considered OCE's submission of a narrative summary of its evidence as supplemental information. As discussed infra, much of the information OCE forwarded was already within the committee's possession, and some of its findings were not supported by the evidence. In some instances, OCE's decision to move forward with its review created confusion among witnesses and delayed the committee's ability to obtain information. On May 10, 2023, an indictment was unsealed in EDNY, charging Representative Santos with 5 counts of wire fraud in connection with a fraudulent political contribution scheme, 3 counts of unlawful monetary transactions in connection with the wire fraud allegations, 1 count of theft of public money in connection with his alleged receipt of unemployment benefits, 2 counts of fraudulent application for and receipt of unemployment benefits, and 2 counts of false statements in connection with his 2020 and 2022 House FD statements. Pursuant to House Rule 11, Clause 3B9 and Committee Rule 18E2, when a member is indicted or otherwise formally charged with criminal conduct in any federal, state, or local court, the committee shall either impanel an ISC or submit a report to the House explaining why it did not do so, and what actions, if any, the committee has taken in response to the allegations, within 30 days of the charges. On June 20, 2023, the committee unanimously voted to expand the ISC's jurisdiction to include allegations in the indictment that Representative Santos may have fraudulently obtained unemployment insurance benefits, which were not within the ISC's initial jurisdiction. On October 10, 2023, a superseding indictment was filed against Representative Santos, charging him with an additional 10 counts related to his conduct during the 2022 campaign: 1 count of conspiracy, 2 counts of wire fraud, 2 counts of false statements, 2 counts of falsification of records, 2 counts of aggravated identity theft, and 1 count of access device fraud. Many of the new allegations in the superseding indictment were already under investigation by the ISC. Representative Santos has pleaded not guilty to all of the charges. His criminal trial is scheduled to begin on September 9, 2024, and anticipated to last at least 3 weeks. B. Deferral request from Department of Justice. Article 1, Section 5 of the Constitution grants each chamber of Congress the power to, quote, punish its members for disorderly behavior and, with the concurrence of 2/3, expel a member, end quote. House rules direct the committee to enforce the standards of conduct for members and investigate any alleged violation by a member of the Code of Official Conduct or of a law, rule, regulation, or other standard of conduct applicable to the conduct of such member. The committee reviews law enforcement deferral requests on a case-by-case basis, taking into consideration the particular circumstances of each case. Prior to the establishment of an ISC, the committee contacted DOJ to determine whether it wished to formally request any actions by the committee to mitigate interference with any investigation of Representative Santos. At that time, DOJ did not make any such requests and indicated that it would follow up with the committee at a later date. On March 24, 2023, DOJ formally requested a full deferral by the committee of all investigative activity relating to Representative Santos. The ISC weighed DOJ's full deferral request against its obligation to safeguard the integrity of the House and the unprecedented nature of this case, which, in addition to serious allegations of misconduct, also involved a formal complaint, a House resolution referring the matter to the committee, a request by an individual who had applied for a position in Representative Santos's congressional office for an investigation of allegations of sexual misconduct, and a referral from OCE. Based on its constitutional and rule-based mandates, the unique circumstances of this case, and the ISC's concern that fully deferring to DOJ until the conclusion of the criminal prosecution would effectively prevent the committee from exercising any oversight of Representative Santos's conduct, the ISC determined to conduct a review of the allegations while continuing to communicate with DOJ to mitigate potential interference. Throughout the ISC's investigation, committee staff had numerous communications with DOJ's Legislative Affairs Office. Those communications led the ISC to delay its review at multiple stages of the investigation and to forego certain investigative steps, including seeking interviews with over 20 individuals. Other witnesses declined to cooperate with the ISC's investigation or asserted their right against self-incrimination under the Fifth Amendment to the U.S. Constitution. C. Investigative steps taken by the ISC. The ISC met 9 times and, over the course of its investigation, the ISC authorized 37 subpoenas and 43 voluntary requests for information, RFIs, leading to its receipt of over 172,000 pages of documents. The ISC also contacted or interviewed over 40 witnesses and reviewed materials from OCE and relevant court records. Representative Santos did not fully cooperate with the ISC's investigation. The ISC issued an RFI to Representative Santos on March 10, 2023. However, he provided only a partial response to the ISC's requests, and many of the documents he did provide came after lengthy delays. On October 17, 2023, the ISC advised Representative Santos of his right, pursuant to Committee Rule 19B3, to respond to the allegations, and requested that he inform it whether he would agree to be voluntarily interviewed and/or to submit a written response under oath or affirmation by November 1, 2023. On October 30, 2023, Representative Santos's counsel advised, quote, "Pursuant to my advice and the pending criminal allegations, Representative Santos declines to voluntarily appear to be interviewed by the committee." End quote. Representative Santos did not submit a written response to the allegations. The ISC carefully considered whether to issue a subpoena to Representative Santos for his testimony, but determined not to take this step to avoid further delaying its investigation, and in recognition of his counsel's previous statements that he would advise Representative Santos to invoke his Fifth Amendment right against self-incrimination. The ISC also believed that Representative Santos's testimony would have low evidentiary value given his admitted practice of embellishment. 3. Findings. A. Overview of findings. Representative Santos has been a member of the United States House of Representatives since 2023, representing New York's 3rd Congressional District. Nancy Marks served as treasurer for Representative Santos's political committees during his 2022 campaign and his unsuccessful 2020 congressional campaign. Representative Santos's congressional campaigns were built around his backstory as a successful man of means, a grandson of Holocaust survivors, and graduate from Baruch College with a master's in business administration from New York University, who went on to work at Citigroup and Goldman Sachs, owned multiple properties, and was the beneficiary of a family trust worth millions of dollars left by his mother, who passed years after the 9/11 terrorist attacks as a result of long-term health effects related to being at one of the towers. No part of that backstory has been found to be true. Since winning his election, Representative Santos has admitted that he embellished parts of his background in order to be taken seriously as a candidate. However, the ISC's review revealed significantly more fraudulent activity by Representative Santos. As an initial matter, members of Representative Santos's own campaign staff viewed him as a fabulist whose penchant for telling lies was so concerning that he was encouraged to seek treatment. His campaign filings and House FD statements are replete with so many errors and omissions that they cannot be reasonably relied upon. Those errors go far beyond an embellished resume and include numerous misrepresentations to the government and the public about his and his campaign's financial activities. Representative Santos's omissions are more than just embellishments intended to cover up his embarrassment about not having the academic pedigree he claimed. His missing disclosures hid his disreputable business dealings that coincided with his campaign for Congress. Representative Santos defrauded his own donors by using their actual and purported campaign contributions to personally enrich himself. His misrepresentations and lack of transparency have continued during his tenure in Congress, including in connection with the ISC's review. Although he has assured the public that he will fully cooperate with the ISC's investigation, he has failed to provide documents in response to an RFI issued over 8 months ago and, through his counsel, declined to consent to a voluntary interview. When reporting errors in his campaign filings with the FEC were initially uncovered, Representative Santos attempted to cast himself as an unknowing victim of Ms. Marks' incompetence and claimed that she went rogue. Far from going rogue, Ms. Marks has admitted to conspiring with Representative Santos to submit false reports to the FEC, and the ISC's record established that Representative Santos was heavily involved in the day-to-day financial operations of his campaigns. Representative Santos had login credentials to access the campaign's bank accounts online, reviewed FEC reports, tracked money as it was coming and going out of the campaign, reviewed invoices, and received weekly finance reports. All of the campaign staff the ISC spoke with testified that Representative Santos had a close relationship with Ms. Marks, with whom he frequently interacted, and one staff member likened the campaign's finances to a black box that only Representative Santos and Ms. Marks could access. At multiple points during his campaigns, staff raised concerns they had about Ms. Marks directly with Representative Santos, including issues relating to her timeliness, reporting, and organization. However, he did not take substantive steps to address those concerns. Instead, he told staff that Ms. Marks was untouchable, ostensibly to continue the schemes they had undertaken. Despite his protestations, many of the public revelations following Representative Santos's election could not have surprised him. Members of his own campaign team presented him with a 141-page vulnerability report on December 1, 2021, which raised a number of issues regarding his background as well as his personal and campaign disclosures, including, among other things, no evidence to support Representative Santos's claims to have graduated with an MBA from New York University and Bachelor of Economics and Finance from Baruch College. Questions regarding how he loaned his 2020 campaign over $80,000 when his personal financial disclosure did not show any assets and only a $55,000 salary. Questions regarding his claims to have an extensive background in money management and growth, but no reported personal investments or assets. Questions regarding his failure to report salary from Harbor City Capital Management, which was under investigation by the Securities and Exchange Commission, SEC, and his failure to file a 2021 FD statement. As a result of the report, Representative Santos was encouraged by his campaign staff to drop out of the race, and when he refused, 3 staffers quit his campaign altogether. This was a key moment wherein Representative Santos could have put an end to all the lies he told, or at a minimum taken steps to correct the record about his background and personal and campaign finances. Instead, he downplayed the significance of the report, telling new staff who were brought on to replace those who had left, and those who stayed, that the report was inaccurate. Following the turnover in his campaign staff, he continued to lie about his background and found more ways to defraud his campaign supporters. He filed a second FD statement filled with falsehoods designed to make him appear wealthier than he was, and furthered the fictional persona he had concocted by falsely reporting more than $500,000 in loans to the FEC. On May 10, 2023, Representative Santos was charged in EDNY with wire fraud in connection with a fraudulent political contribution scheme, unlawful monetary transactions in connection with the wire fraud allegations, theft of public money in connection with his alleged receipt of unemployment benefits, fraudulent application for and receipt of unemployment benefits, and false statements in connection with his 2020 and 2022 FD statements. A superseding indictment was filed on October 10, 2023, charging Representative Santos with additional violations related to his 2022 campaign, including allegations of falsifying FEC reports in connection with a $500,000 personal loan that was never made, falsifying the names of contributors to his campaign, engaging in aggravated identity theft and access device fraud, and enriching himself through a fraudulent contribution scheme. He has pled not guilty to all of the criminal charges. The ISC determined there was substantial evidence of violations of federal law, House rules, and other applicable standards related to many of the allegations charged in the indictment, and substantial evidence of additional uncharged, unlawful, and unethical conduct. These additional violations relate to falsely reported loans reportedly received by his 2020 campaign and Leadership Political Action Committee, GADS PAC, improper loan repayments to Representative Santos, systemic reporting errors in his 2022 and 2022 campaign's FEC filings, and substantial evidence that campaign funds were converted to personal use. The ISC also identified additional errors and omissions in his 2020 and 2022 FD statements, as well as violations of federal law and House rules related to his unfiled 2021 and 2023 FD statements, which were not charged in the indictment. The ISC also found that Representative Santos failed to meet his duty of candor with respect to the ISC's investigation and instead presented the ISC with misrepresentations and delay tactics. B. Substantial evidence of violations of federal law, House rules, and other applicable standards of conduct. 1. Campaign finance violations. The ISC uncovered significant campaign finance violations by Representative Santos and his campaign committees during the 2020 and 2022 election cycles. Many of the errors related to improper reporting to the FEC, including with respect to falsely reported personal loans from Representative Santos and thousands of dollars in unreported disbursements and receipts, including excessive contributions from a state political committee that Representative Santos helped manage. Representative Santos has sought to blame Ms. Marks for all of the errors in his campaign reports by offering evolving arguments that conflict with one another. Through his prior counsel, Representative Santos initially claimed that he had no knowledge of those errors at the time they were made, as he put his trust in Ms. Marks. More recently, his criminal defense attorney asserted that the congressman's recollection is that he did call into question financial discrepancies that he observed from Ms. Marks and her staff during the campaign. In support of that new position, counsel produced emails that Representative Santos sent Ms. Marks in the fall of 2021, raising questions about why certain deposits were not reported on the campaign's FEC reports. The emails indicate that Representative Santos combed through FEC reports and confronted Ms. Marks and her staff, telling them he was, quote, very upset because there is missing money on my filing and that's hurting me, end quote. In response, Ms. Marks' staff ensured that Representative Santos had access to bank accounts for DeVolder Santos for Congress, GADS PAC, his leadership PAC, DeVolder Santos Victory Committee, a joint fundraising committee, and Rise NY PAC, RISE, the state PAC that Representative Santos helped manage, and asked Representative Santos to identify any discrepancies. After Representative Santos had a meeting with Ms. Marks regarding his questions, Ms. Marks' staff sent a detailed email explaining that several of the specific discrepancies raised by Representative Santos were not in fact errors, e.g., a donor had not contributed as much as pledged, or the date of their contribution did not fall within the relevant reporting period. Ms. Marks' staff noted that there were only 2 items identified by Representative Santos that, quote, do need to be rectified. One was reporting an $80,000 loan Representative Santos made to his campaign, which he knew to be fictitious, as discussed further below. The other was an unreported $10,800 contribution from an individual that DOJ has alleged was defrauded by Representative Santos. Ms. Marks amended the relevant FEC report to disclose the fictitious loan, but not the $10,800 payment. Rather than exonerate Representative Santos, these materials only further underscored that Representative Santos was highly involved in his campaign's financial operations, focused on projecting large fundraising numbers on his FEC reports, and aware of issues relating to the campaign's reporting, but failed to take sufficient corrective steps. Representative Santos's initial counsel before the ISC also served as counsel to the campaign, and their duties included reviewing the campaign's FEC filings prior to their submission. In August 2021, Representative Santos stated that he wanted counsel to serve as an extra set of eyes to help review the campaign's reports to be 100% on it all. In reality, however, his campaign counsel did not review the campaign's reports until later in 2022, and the law firm does not appear to have been entrusted with the campaign's underlying bank records, which would have shown that the campaign's reports to the FEC contained errors and omissions. When reviewing the reports, counsel made clear that their assumption was that the information in the reports was reported correctly, nullifying any effective assistance that could have been provided. The committee has previously explained that members must be held to account when they know or should know of ethical violations that occur within the organizations they oversee, abdicate their duty to supervise the staff to whom they delegate substantial responsibilities, disregard concerns as they are brought to their attention, and hamstring compliance professionals by not supplying necessary information or providing false information. The ISC was not swayed by Representative Santos's attempts to blame others. He was the ultimate beneficiary and knowing participant of much of the fraudulent reporting, as the falsely reported personal loans and contributions helped him meet benchmarks needed to win the support of the National Party and project a strong campaign to the public. Even if Representative Santos was not aware of all of the other errors in his campaign reports relating to other receipts and disbursements, he had his own concerns and was repeatedly advised by multiple members of his team about concerns regarding Ms. Marks, but he failed to take meaningful action. The committee has determined on several occasions that misconduct that occurs in connection with a successful election to the House is subject to review by the committee and may be the basis for a finding that a member has violated the Code of Official Conduct. Just as it is essential to the integrity of the House that members serve in an ethical manner, it is essential that they arrive at the institution in such a manner. 1. Substantial evidence of violations related to personal loans. A. Background. According to FEC reports, during the 2020 and 2022 elections, Representative Santos made personal loans totaling nearly $800,000 to his campaign committee and $27,000 in personal loans to his leadership PAC, GAD's PAC. As detailed below, the ISC determined that there is substantial evidence that most of the reported personal loans were not actually made or properly disclosed to the FEC. Representative Santos was also improperly repaid for loans that were not made. The following chart summarizes the 6 personal loans Representative Santos's campaign committee, DeVolder Santos for Congress, reported, versus whether any loans were actually made during the 2020 election cycle. Full chart omitted from audio. The chart shows a total of 6 loans, totaling $81,250 reported, with only $3,500 actually loaned, between January 31, 2020 and July 15, 2020. The ISC reviewed the campaign's bank records as well as financial statements for accounts held by Representative Santos, but found no evidence that 5 of the 6 reported loans were ever made. With respect to the first 3 loans, the campaign's December 2019 and January 2020 bank statements did not show Representative Santos transferring any funds to the campaign or transfers to the campaign from any other source equaling the reported loans. The campaign's March 2020 statement did show a $2,000 wire from George A. DeVolder Santos, and the ISC located a corresponding transfer from one of Representative Santos's personal savings account to the campaign on March 9, 2020, for the same amount. However, The ISC found no records of a $50,000 or $1,200 loan from Representative Santos on or around March 31, 2020, and June 25, 2020. There was an additional transfer to the campaign that originated from a bank account controlled by Representative Santos, a $1,500 cashier's check deposited by the campaign on February 13, 2020. That check was not reported to the FEC. Representative Santos benefited politically and financially from the reporting of the loans. The fictitious loans inflated his 2020 campaign's ending cash on-hand totals that were reported to the FEC. Full chart omitted from audio. The chart has 3 rows, showing the reported cash on hand at close of reporting period and the actual ending account balance for January 31, 2020, April 15, 2020, and July 15, 2020, comprising the quarterly reports for the 2020 campaign. The amounts were reported $4,297.81, actual ending balance $150.43, $54,988.51, actual ending balance $1,310.57, reported $73,355.64, actual ending balance $13,761.88. Despite reporting the higher cash on-hand totals, the reality was that the campaign did not have the funds to pay outstanding debts. At least one campaign staffer went 8 months without being paid for his work. Representative Santos also received disbursements from the campaign that were reported as repayments for 5 of the personal loans, 4 of which were not made. Loan date December 31, 2019, in the amount of $5,300, repayment $5,300 via campaign check dated November 18, 2020. Loan date January 3, 2020, loan amount $18,550, repayment $18,500 via campaign wire on December 30, 2020. Loan date January 10, 2020, loan amount $4,200, repayment $4,200 via campaign check on November 18, 2020. Loan date March 10, 2020, loan amount $2,000. Loan repayment $2,000 via campaign check on November 18, 2020. Loan date March 31, 2020. Loan amount $50,000. Loan repayment not applicable. Loan date June 25, 2020. Loan amount $1,200. Repayment details $1,200 via campaign check on November 18, 2020. For a total repaid to Representative Santos of $31,200. The 5 repayments were reported to the FEC in Schedule C of the campaign's amended 2020 year-end report and were deposited into accounts owned and controlled by Representative Santos. As noted previously, the ISC only found evidence that Representative Santos made the March 10, 2020 loan for $2,000. Thus, he was reimbursed for 4 campaign loans totaling $29,200 that were not made. The campaign also raised additional funds after the election for purposes of retiring the campaign's purported debt. In response to requests from the ISC, Representative Santos's counsel has stated that he put his trust in Ms. Marks, that it is unclear whether Representative Santos ever made any personal loans to his 2020 campaign, and that the reporting of these loans was a result of Ms. Marks' incompetence. Although counsel advised that they would update the committee when we receive more information on this issue, no further information or materials were provided by Representative Santos regarding the 2020 personal loans he purportedly made to his campaign or the repayments he received. Evidence provided by other witnesses indicates that, contrary to counsel's assertions, the reports of loan payments were based on information that Representative Santos provided to Ms. Marks, and Representative Santos was aware of the reported loans at the time. Representative Santos and Ms. Marks exchanged contemporaneous text messages discussing that at least one of the loans had not been made but had been included on the campaign's reports, and his campaign staff testified that Representative Santos discussed making $80,000 in loans to his 2020 campaign. In December 2021, a vulnerability report commissioned by the campaign was shared with Representative Santos. The report raised similar questions regarding his ability to make personal loans to his 2020 campaign. Quote, "In 2020, Santos loaned his campaign more than $81,000. His personal financial disclosure from 2020 does not show any assets and only a $55,000 annual salary." End quote. The report led to the departure of some of his campaign staff. However, Representative Santos did not cause his campaign reports disclosing these loans to be amended and said that the contents of the report were not worrisome to him. The following chart summarizes the loans Representative Santos's campaign committee, DeVolder Santos for Congress, originally reported receiving from him during the 2022 election cycle. FEC Filing 2021 July Quarterly Report, Loan Date June 30, 2021, Loan Amount $80,000. FEC Filing 2022 April Quarterly Report, Loan Date March 31, 2022, Loan Amount $500,000. FEC Filing 2022 Post General Report, Amended, Loan Date October 26, 2022, Loan Amount $125,000. Total loan amounts $705,000. The ISC reviewed the campaign's bank records and other accounts held by Representative Santos, but found no evidence of the $80,000 and $500,000 loans ever being made. Representative Santos did not have sufficient funds in his bank accounts to loan his campaign those amounts. Nor did the campaign receive funds from Representative Santos's accounts on or around those dates for those loan amounts. The campaign's account ending balances on June 30, 2021, and on March 31, 2022 were $75,090.30 and $85,616.14. However, the campaign reported significantly higher ending cash on-hand balances to the FEC of $292,712.86 and $821,293.77 for the same time periods. In its 2023 April Quarterly Report, on April 15, 2023, Representative Santos's campaign committee did not report the $80,000 and $500,000 loans. Instead, the campaign reported personal loans as follows. Loan date September 10, 2022, loan amount $300,000. Loan date September 20, 2022, loan amount $100,000. Loan date October 10, 2022, loan amount $100,000. Loan date October 17, 2022, loan amount $90,000. Loan date October 26, 2022, loan amount $125,000, for a total amount of $715,000. Representative Santos's campaign has not amended the relevant past filings with the same information, which more accurately reflects the campaign's bank records. The ISC reviewed evidence that the campaign's bank account received $715,000 from several bank accounts Representative Santos owned or controlled on the following dates. Bank account Personal Savings Account Number 1, date of check September 10, 2022, date of deposit September 19, 2022, amount $300,000. Personal Savings Account Number 1, date of check September 20, 2022, date of deposit September 21, 2022, amount $100,000. Personal Savings Account Number 1, October 10, 2022, date of deposit October 13, 2022, amount $100,000. Bank account DeVolder Organization Checking, date of check October 17, 2022, date of deposit October 18, 2022, amount $90,000. Bank account, Devolder Organization checking. Date of check, October 16, 2022. Date of deposit, October 26, 2022. Amount, $125,000. Total deposited amount, $715,000. Just before making these loans to his campaign, Representative Santos and two companies he owned or controlled were paid $800,000 in 3 installments. Footnote 65. The transfers originated from Individual 4 and an entity controlled by Individual 4's family member, Company 2. The ISC found some evidence that Representative Santos provided some services to Individual 4 and Company 2. However, given the timing, amounts, and other circumstances of the payments, the ISC had serious questions regarding whether these payments were intended to benefit Representative Santos's campaign and thus were unlawful, excessive contributions. The ISC was unable to further pursue these questions due to DOJ's specific deferral requests. End footnote. Without these payments, Representative Santos would not have had the funds to make these loans to his campaign. Footnote 66. Even after the 2022 election, Representative Santos's campaign continued to fundraise for retirement of the debt. See Exhibit 14. End footnote. Representative Santos's counsel told the FEC that the initial reporting of loans during the 2022 campaign was baffling and that, quote, for some reason, Ms. Marks reported the wrong amounts, totals, and dates, end quote. Counsel's attempt to paint the falsely reported loans as a mix-up of dates and other numbers was not supported by the evidence, and there was no explanation provided for how Ms. Marks could have reported the wrong numbers for loans that did not exist at the time they were reported. The ISC requested, but Representative Santos did not produce all of his communications regarding these loans. Footnote 68. Representative Santos provided some communications and/or contracts with Individual 4 and Company 2, but he did not produce communications with members of his campaign staff relating to any of the reported personal loans. End footnote. Other individuals who cooperated with the ISC's review provided records showing that, throughout his 2022 campaign, Representative Santos received or exchanged emails indicating that he was aware that his campaign had reported receiving $80,000 and $500,000 in loans from him. He also received internal campaign weekly finance reports stating that he made $580,000 in personal loans to the campaign throughout spring 2022. On October 5, 2023, a one-count criminal information was filed in EDNY charging Ms. Marks with conspiring to commit offenses against the U.S. government in connection with falsely reporting the March 31, 2022 $500,000 personal loan, among other offenses. According to the information, Ms. Marks and co-conspirator 1, Representative Santos, agreed to falsely report to the FEC that he had loaned his campaign significant sums of money when he had not made the reported loans and did not have the funds necessary to make such loans. The information alleged that the $500,000 loan in particular was falsely reported to make the campaign committee appear more financially sound in order to mislead the FEC, National Republican Congressional Committee, NRCC, and the public, so that Representative Santos would receive campaign support from the NRCC. Ms. Marks pled guilty to the conspiracy charge on the same date it was filed. During her guilty plea hearing, Ms. Marks testified under oath, quote, "I admit to all the actions attributed to me in the information," end quote, and, quote, "I filed the first quarter 2022 report stating that $500,000 was loaned to the campaign by Representative Santos and the money was not received at that time." End quote. On October 10, 2023, a superseding indictment was filed, charging Representative Santos with additional offenses, including conspiring to falsify records and related offenses in connection with the reporting of the $500,000 March 31, 2022 personal loan. On October 6, 2023, Representative Santos pleaded not guilty to all of the charges. The ISC determined there was substantial evidence that Representative Santos was an active and knowing participant in a scheme to falsely report personal loans during his 2022 campaign, based on Ms. Mark's guilty plea and sworn admissions to the court, as well as contemporaneous records evidencing Representative Santos's awareness of how the loans were being reported. 3. 2022 Leadership PAC Personal Loans. The following chart summarizes the loans GADS PAC, a leadership political action committee affiliated with Representative Santos, reported receiving from him during the 2022 election cycle. FEC filing 2021 October quarterly report. Loan date July 10, 2021. Loan amount $25,000. FEC filing 2022 October quarterly report. Loan date July 15, 2022. Loan amount $2,000. Total amount loaned $27,000. The ISC reviewed GADS PAC's bank statements and Representative Santos's financial records, but did not find any evidence that these two loans were made. In July 2021, GADS PAC's beginning bank account balance was $507,015.70, and its ending balance was $3,715.70, with the only transaction being a $2,000 check paid to another candidate committee. While GADS PAC's July 2022 bank statement showed more financial activity, including $22,800 and $5,000 wire transfers it received from DeVolder Santos Victory Committee on July 12th and 13th, 2022, which were not reported to the FEC, no funds were received from Representative Santos's personal accounts. As was the case with the 2020 loans, counsel for Representative Santos told the ISC it was unclear whether Representative Santos made any personal loans to GADS PAC and asserted that Ms. Mark's incompetence was to blame for the reporting of the loans. The ISC did not find evidence that Representative Santos was repaid by GADS PAC for these fictitious loans. However, GADS PAC falsely reported making the following disbursements, titled Loan Repayment to Representative Santos. FEC filing July 15, 2022 quarterly report. Disbursement dates April 10th, May 8th, June 30th, and June 30th, 2022. Disbursement amounts $3,000, $5,000, $14,800, $2,200. According to GADS PAC's bank records, a transfer for one of these amounts, $14,800, actually went to a state political committee on July 12, 2022. This disbursement was not reported to the FEC by GADS PAC or the political committee. B. Relevant laws, rules, and other applicable standards of conduct. A candidate's principal campaign and affiliated committees must accurately report information to the FEC, including all loans and contributions they receive and disbursements they make. Candidates may make unlimited contributions to their own campaigns so long as they are made from a candidate's personal funds. Personal funds include 1. Any asset that the candidate had legal right of access to or control over under applicable state law at the time the individual became a candidate, and with respect to which the candidate had legal and rightful title or an equitable interest. 2. The candidate's income received during the current election cycle, and 3. Certain amounts derived from joint assets owned by the candidate and the candidate's spouse. Such contributions by candidates to their own campaigns are considered loans, and although they are not subject to the same monetary limits as other contributions, they are subject to additional reporting requirements. The loan must be itemized by the campaign committee and continuously reported until paid off. When a campaign committee discovers that an earlier report contained erroneous information, it must file an amended report. If a committee has net debts outstanding after an election is over, a campaign may accept contributions after the election to retire the debts. The Federal Election Campaign Act, FECA, and its implementing regulations also prohibit the use of campaign funds for personal use. A contribution shall be considered to be converted to personal use if it is used to fulfill any commitment, obligation, or expense of a person that would exist irrespective of the candidate's election campaign or duties as a federal officeholder. 18 U.S.C. Section 371 provides that if two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose, and one or more of such persons do any act to effect the object of the conspiracy, each shall be fined under this title or imprisoned not more than 5 years or both. 18 U.S.C. Section 1001A applies to anyone who knowingly and willfully 1. Falsifies, conceals, or covers up by any trick, scheme, or device a material fact. 2. Makes any materially false, fictitious, or fraudulent statement or representation. Or 3. Makes or uses any false writing or document knowing the same to contain any materially false, fictitious, or fraudulent statement or entry. 18 U.S.C. Section 1519 states, whoever knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation or proper administration of any matter within the jurisdiction of any department or agency of the United States, or any case filed under Title 11, or in relation to or contemplation of any such matter or case, shall be fined under this title, imprisoned not more than 20 years, or both. House Rule 23, Clause 6b states a, quote, member, delegate, or resident commissioner may not convert campaign funds to personal use in excess of an amount representing reimbursement for legitimate and verifiable campaign expenditures, end quote. Accordingly, the Ethics Manual explains members, quote, must be able to verify that campaign resources have not been so misused, end quote, and cautions, members and their campaign staffs should bear in mind that the verification requirement imposed by the House rules is separate from and in addition to whatever record-keeping requirements are imposed by the FEC on federal candidates generally, or with regard to members who are candidates for a state or local office, the requirements imposed by applicable state or local law. Pursuant to paragraph 2 of the Code of Ethics for Government Services, members are expected to uphold the laws and legal regulations of the United States and never be a party to their evasion. Members must also act in a manner that reflects creditably on the House, pursuant to House Rule 23, Clause 1. C. Findings. As detailed in the factual background, the ISC received substantial evidence that personal loans were falsely reported by Representative Santos's campaign committee and leadership PAC during the 2020 and 2022 elections, and campaign funds were converted to personal use to the extent that Representative Santos received repayments from his campaign for loans that were not made. The ISC found substantial evidence that Representative Santos was an active and knowing participant in a scheme to falsely report personal loans during his campaigns, given his contemporaneous communications regarding the loans, the fact that he was repaid for some of the loans, and his involvement in the oversight of his campaign's financial operations. Moreover, Ms. Marks pled guilty and testified under oath to conspiring with Representative Santos to falsely report loans that were not made in an effort to deceive the FEC, NRCC, and the public regarding the strength of his campaign. These actions did not reflect creditably on the House and resulted in a prolonged failure by Representative Santos to uphold laws and regulations of the United States, including provisions of FECA and the FEC's implementing regulations. Accordingly, the ISC found Representative Santos violated House Rule 23, Clause 1 and Paragraph 2 of the Code of Ethics for Government Services. 2. Additional FEC reporting errors and personal use of campaign funds. A. Background. In addition to the falsely reported personal loans, there were numerous other errors and omissions in Representative Santos's campaign finance reports. Those reports also contained evidence that campaign funds were converted to Representative Santos's personal use. In the supplemental information transmitted to the committee, OCE noted that Representative Santos's campaign reported 40 disbursements valued between $199 and $200 in 2021, 37 of which were for exactly $199.99, but OCE was unable to verify the legitimacy of these expenditures. OCE also highlighted certain unreported transfers and unidentified deposits to and from the campaign bank account in 2022, including an unreported $20,000 transfer from the campaign to DeVolder Organization on November 29, 2022. Along with other inconsistencies between FEC-reported disbursements and campaign expenditures. The ISC confirmed these reporting discrepancies. With respect to the disbursements between $199 to $200, the ISC found that these did not correspond to actual payments by the campaign. The $20,000 transfer to a DeVolder Organization account, requested by Ms. Marks' staff, was made at a time when that account had a negative balance. In the week after it was transferred to DeVolder Organization, it was used to make about $6,000 worth of purchases at Ferragamo stores, withdraw $800 in cash from an ATM at a casino, withdraw $1,000 in cash from an ATM near Representative Santos's apartment, and to pay Representative Santos's rent. The ISC uncovered more extensive errors and inconsistencies than discussed in public reports or OCE's supplemental information. There were numerous unreported transfers to and from the campaign bank account, including transfers of campaign funds to accounts owned or controlled by Ms. Marks, an unreported $10,000 transfer from the campaign to Representative Santos's company, DeVolder Organization, and unreported transfers worth over $50,000 between the campaign and RISE. Those transfers included an $18,700 January 25, 2022 transfer from the campaign to RISE, a $7,000 deposit from RISE to the campaign on February 1, 2022, an $18,800 transfer from the campaign to RISE on April 29, 2022, and two unreported deposits of $20,060 and $15,000 from RISE to the campaign on June 21st and September 26, 2022, respectively. RISE is a New York State political committee that was created by Representative Santos shortly after his 2020 election, which his sister, Tiffany Santos, helped manage, and whose treasurer was Ms. Marks. According to one campaign staffer, Representative Santos was advised by his campaign counsel to close down RISE while running for federal office. This guidance was not followed. Instead, money flowed back and forth between Representative Santos's campaign and RISE and was not reported to the FEC. According to Ms. Marks' October 5, 2023 guilty plea, Representative Santos was also involved in a conspiracy to falsify information related to the names of certain campaign contributors. Specifically, Ms. Marks testified that she, in agreement with Representative Santos, quote, filed a list of false donors with the FEC on the year-end 2021 report, knowing it was not true, and the donors, who are the real people, didn't give her permission to use their names, end quote. As with the falsified loans discussed above, Ms. Marks testified that her and Representative Santos's actions were intended to, quote, benefit and to obtain money for his campaign by artificially inflating his funds to meet thresholds set by a national political committee, end quote. OCE stated in its supplemental information that, based on the testimony of one campaign staffer and its review of the campaign's bank statements, it had identified, quote, a pattern of campaign committee expenditures for travel and other personal services that may not have represented legitimate and verifiable campaign expenditures, end quote. Without Representative Santos's cooperation, the ISC was unable to verify whether such expenditures, and others detailed below, were incurred for bona fide campaign purposes. However, certain expenditures on their face do not appear to have a campaign nexus. The campaign incurred significant travel expenses for flights, hotels, Ubers, and meals. Witnesses affiliated with the campaign had conflicting testimony regarding Representative Santos's out-of-district travel. One witness who was involved with the campaign in 2022 testified to OCE that there were only 2 trips taken out of state during the campaign, to Washington, D.C. and Florida. However, additional witnesses affiliated with the campaign described Representative Santos's out-of-district campaign travel differently to the ISC, with one recalling that he traveled once per month, whereas another expressed concern about the high frequency of his out-of-district travel for the campaign. The staffer who had concerns about the amount of travel testified that they were, quote, worried about the look of the campaign spending all this money on all these dinners and travel outside of the district, end quote. The staffer raised those concerns with Representative Santos, who replied, quote, but these are donor dinners or constituent dinners or, prospective donor dinners, end quote. Another staffer who witnessed Representative Santos use campaign funds for meals and Ubers said that they did not have concerns about the spending, but also noted that Representative Santos, quote, was definitely a high roller, end quote, who frequently went to donor dinners. In addition to the travel expenses, OCE identified several specific expenditures as raising concerns of potential personal use of campaign funds. $2,281.52 spent at resorts in Atlantic City from July 23 to July 24, 2022. $1,400 at Virtual Skin Spa in Jericho, New York in July 2022, and $225 at CityMD in Huntington, New York on August 27, 2022. With respect to the Atlantic City expenditures, the ISC did not receive records of any political or campaign events occurring in Atlantic City at that time. Representative Santos's calendar entry for July 23, 2022 was blank, and there was only one event at 8 p.m. on the 24th titled NRCC Candidate. Another former staffer did not recall, quote, any sort of fundraising or campaign things in Atlantic City, end quote, but did recall that Representative Santos told him that he enjoyed visiting casinos to play roulette, often with his husband. The ISC also identified a July 7, 2022, $3,332.81 Airbnb expenditure reported to the FEC as a hotel stay. Review of the campaign's calendar on that date indicated that Representative Santos was, quote, off at the Hamptons for the weekend, end quote. The ISC also reviewed additional taxi and hotel charges on the campaign credit card that were incurred in Las Vegas in December 2021, during a time when Representative Santos had told his campaign staff that he was on his honeymoon and there were no corresponding campaign events on his calendar. Several other expenditures related to spa services and or cosmetic procedures could not be verified as having a campaign nexus. For example, during the 2020 campaign, a $1,500 purchase on the campaign debit card was made at Mirza Aesthetics. This expense was not reported to the FEC and was noted as Botox in expense spreadsheets produced to the ISC by Ms. Marks. Similarly, The $1,400 charge at Virtual Skin Spa was a campaign debit card purchase that was also described as Botox in the spreadsheets produced by Ms. Marks. The ISC also identified an unreported PayPal payment of $1,029.30 to an esthetician associated with a spa in Rhinebeck, New York. In correspondence with the FEC, Representative Santos has admitted that there were systemic errors and omissions within his campaign's reports to the FEC, including the existence of the $199.99 disbursements discussed above. According to the letter, the campaign's FEC reports appear to be riddled with errors and omissions. The respondent had no knowledge of the errors and omissions at the time the reports were filed. The respondent put his trust in his former treasurer, who has filed FEC reports for multiple members of Congress, to accurately keep records and file reports. This was clearly a mistake. When respondent learned of these issues, he promptly took steps to rectify these problems. After firing Nancy Marks, the former treasurer, and hiring a new treasurer, the systemic nature of the problems was uncovered. To start, after reviewing the campaign's bank accounts, there is no evidence the $199.99 disbursements ever existed. It is unclear why Ms. Marks included these items in the report. Although Representative Santos asserted in this correspondence that he was only later made aware of issues with the campaign's FEC reporting, multiple witnesses testified that they had concerns about Ms. Marks' bookkeeping abilities, and several raised those concerns directly with Representative Santos. One campaign staffer told the ISC that, quote, "It was difficult to get an accurate reporting," end quote, of contributions that were coming in, and they discussed these issues with Representative Santos on more than 5 occasions. Answer: There were conversations on the phone, on team calls, a lot of team calls, I would say on probably mostly the team calls, and we would talk about reporting. We couldn't get an accurate number of what had actually come in because there were duplicates and incorrect information in the reports. Question: What was Representative Santos's reaction to being told about your concerns regarding Ms. Marks? Answer: I'll talk to her. That was it. Another member of his campaign staff recalled specifically discussing the campaign's reporting of $199.99 disbursements with Representative Santos in 2021. I remember the $199.99 disbursements coming to light, and I couldn't tell you the time frame. It was near the end of our tenure, and I remember discussing it with Witness 3 and then bringing it up to at least George, and I can't recall if Nancy as well. But we didn't receive a satisfactory answer. It was just, well, I'll have to check with Nancy, get clarification on that. We never really got a straight answer on that. While Representative Santos was made aware of these concerns on multiple occasions, no changes were made to address those concerns, and as noted previously, he was actively conspiring with Ms. Marks to falsify his campaign's reports. Furthermore, while the campaign has provided more accurate information related to the 2022 personal loans in its recent reports, it has not amended past reports to address the loan discrepancies or any of the other systemic errors discussed above, such as the $199.99 disbursements and unreported transfers and disbursements. B. Relevant laws, rules, and other applicable standards of conduct. Campaign committees must file reports disclosing all receipts and disbursements. These reports must include, among other things, the amount and nature of the receipts and disbursements. In addition, the reports must disclose, quote, the identification of each person who makes a contribution to the reporting committee during the reporting period, whose contribution or contributions have an aggregate amount or value in excess of $200 within the calendar year, together with the date and amount of any such contribution. End quote. The individual contribution limit during the 2021 to 2022 election cycle was $2,900 per election. On June 23, 2022, the FEC released an advisory opinion, AO, that allowed candidates in the state of New York to accept an additional $2,900 due to the primary election date changing from June 28, 2022 to August 23, 2022. A campaign committee may accept up to $5,000 per year from a non-connected PAC. As noted previously, FECA and its implementing regulations prohibit the use of campaign funds for personal use. A contribution shall be considered to be converted to personal use if it is used to fill any commitment, obligation, or expense of a person that would exist irrespective of the candidate's election campaign or duties as a federal officeholder. The Ethics Manual also notes that certain kinds of campaign outlays, such as expenditures for travel, meals, and the purchase of goods and services, by their nature raise a concern of personal use. As discussed above, House Rule 23, Clause 6b states a, quote, member, delegate, or resident commissioner may not convert campaign funds to personal use in excess of an amount representing reimbursement for legitimate and verifiable campaign expenditures, end quote. Accordingly, the Ethics Manual explains members, quote, must be able to verify that campaign resources have not been so misused, end quote. In addition, all funds of a political committee, quote, shall be segregated from and may not be commingled with the personal funds of any individual, end quote. Furthermore, Paragraph 2 of the Code of Ethics for Government Service requires members to uphold the laws and regulations of the United States, including provisions of the FECA and the FEC's implementing regulations, and to never be a party to their evasion. Finally, House Rule 23, Clause 1 states that, quote, a member of the House shall behave at all times in a manner that shall reflect creditably upon the House, end quote. C. Findings. The ISC determined that the systemic errors and omissions in Representative Santos's campaign reporting were more than mere carelessness by his treasurer. Rather, they were part of an overall scheme to avoid transparency about his campaign's finances. The myriad reporting errors obscured numerous suspect transactions, including unreported transfers of funds directly to Representative Santos's personal and business accounts, as well as expenditures raising significant concerns of potential personal use of campaign funds. At minimum, Representative Santos failed to take reasonable steps to prevent or correct the errors despite concerns raised to him by his campaign staff, resulting in the misreporting of substantial sums of receipts and disbursements. By engaging in the above conduct, Representative Santos failed to uphold the laws and regulations of the United States, including provisions of FECA and its implementing regulations, and was a party to their non-compliance, in violation of Paragraph 2 of the Code of Ethics for Government Services. As a result of Representative Santos's poor campaign record-keeping, the legitimacy of his campaign spending cannot be verified and has called into question the integrity of the House, contrary to Clauses 1 and 6 of House Rule 23, the Code of Official Conduct. 3. Fraudulent Political Contribution Scheme. A. Background. On November 1, 2021, Redstone Strategies, LLC, Redstone, a Florida-based limited liability company, was formed in Florida. Redstone was created shortly after a congressional campaign committee raised complaints against Red Strategies USA, LLC, Red Strategies, another company affiliated with Representative Santos, which had been formed in May 2021. An individual who worked for another New York congressional campaign during the 2022 election cycle informed the ISC that Representative Santos had introduced Red Strategies to the other campaign in 2021, describing it as, quote, a widely used campaign organization for plenty of the politicians in Mar-a-Lago, end quote. Representative Santos made it seem like he had never met the other individuals involved with the company, who were in fact all associates of his, and he did not disclose his own role in the company. Red Strategies was hired by that campaign and made over $110,000 for digital consulting and fundraising and compliance consulting. The campaign, quote, cut total ties with Red Strategies, end quote, when the campaign staffer realized that Representative Santos had not disclosed his connection to the company. In December 2021, the staffer confronted Representative Santos about Red Strategies via text message, stating, quote, you pretended you didn't even know the company when you actually own the company, end quote, and, quote, you opened the company May 4th, end quote. In response, Representative Santos attempted to deny having any affiliation to Red Strategies at the time he introduced the company to the campaign. He stated that he, quote, bought into Red Strategies at the end of August, end quote, even though DeVolder Organization had been listed on the initial corporate filings in May 2021, and defended himself as a, quote, businessman with a very good reputation for 13 years, end quote. Redstone had two authorized managers, Representative Santos's single-member LLC, DeVolder Organization, and Jason Benoit and Associates, Inc. Representative Santos exchanged text messages with his business associate regarding Redstone's corporate formation, and both individuals were authorized signers on Redstone's checking and savings bank accounts. According to bank account opening documents, Redstone provided political services, and in January 2022, Representative Santos signed a contract as Redstone's managing partner with REVV LLC, a firm that offers online donation platform services. However, Representative Santos also used his Redstone email account to engage in capital introduction services and, as detailed later in this section, the company was described as an independent expenditure political committee formed exclusively to aid Representative Santos's congressional campaign. Representative Santos received funds from Redstone on various occasions in 2022. According to bank records, at least $200,000 was transferred from Redstone's bank accounts to Representative Santos's personal bank accounts. On April 1, 2022, Representative Santos sent a text message to one of Ms. Mark's staffers with access to the account for RISE, Individual 3. Quote, please do this wire for RISE ASAP. It's for ads that we were supposed to pay and I forgot, end quote, and included wire instructions for Redstone he had received from Individual 2 earlier that day. Following this text exchange, $6,000 was transferred from RISE to Redstone, which was then transferred from Redstone to Representative Santos's personal checking account. Prior to the $6,000 transfer, Representative Santos's personal checking account had a balance of $136.93. The ISC did not find evidence that Representative Santos used the funds from RISE to pay for advertisements. After the funds were deposited, $5,000 was withdrawn and personal credit card balances were paid. In October 2022, an individual using a Redstone email account contacted Contributor 1 and Contributor 2 seeking contributions to Redstone to support Representative Santos's candidacy. In those solicitations, Redstone was identified as an independent expenditure committee, quote, set up to exclusively, end quote, support Representative Santos's candidacy and, quote, dedicated to helping George Santos win New York 03, end quote. Despite these representations, Redstone was not registered with the FEC. Representative Santos also contacted Contributor 2 directly, sending the following message, quote, I'm needing some help on the outside for next week on TV. Can I have the guys from the outside give you a buzz? Can you help? It's coming down to the wire and these people are on me, end quote. On October 21, 2022, Redstone's bank account received a $25,000 wire from an account affiliated with Contributor 2. From there, $25,000 was transferred from Redstone's account to Representative Santos's personal checking account. On October 26, 2022, Redstone's bank account received a $25,000 wire from an account affiliated with Contributor 1. On the same date, the $25,000 was transferred from Redstone to a different personal checking account owned by Representative Santos. After the $50,000 from Redstone was deposited into Representative Santos's personal accounts, the funds were used to, among other things, pay down personal credit card bills and other debt, make a $4,127.80 purchase at Hermes, and for smaller purchases at OnlyFans, Sephora, and for meals and for parking. The ISC did not find evidence showing that the contributions received from Contributors 1 and 2 were used to support Representative Santos's candidacy. In addition, a senior member of Representative Santos's campaign staff told the ISC, quote, "The only independent expenditure that was helping the campaign was the NRCC doing their thing that they would do for young guns, but I don't recall Redstone strategies," end quote. In May 2023, a federal indictment alleged that Representative Santos, quote, "devised and executed a scheme to defraud supporters of his candidacy for the House and to obtain money from them by fraudulently inducing supporters to contribute to Company Number 1, Redstone Strategies, under the false pretense that the money would be used to support his candidacy," end quote, through the purchases of advertisements and other expenditures. Representative Santos was charged with using contributions raised from Contributors 1 and 2 for personal expenses, including luxury designer items and credit card payments. Following the indictment, Representative Santos publicly distanced himself from Redstone. He denied that he ever served as a manager of Redstone, despite signing contracts on its behalf as a managing partner, and said that his name was included in its business filings in error, despite exchanging texts with his co-owner regarding the firm's initial corporate filings. Months prior to the filing of the indictment, the ISC requested records from Representative Santos related to Redstone, and his counsel provided a 1099 tax form indicating Representative Santos received $176,298.06 in non-employee compensation from Redstone. Representative Santos did not provide the ISC with other records, such as his communications, related to Redstone. B. Relevant laws, rules, and other applicable standards of conduct. 18 U.S.C. Section 1343 states, "Whoever, having devised or intending to devise any scheme or artifice to defraud or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises, transmits or causes to be transmitted by means of wire, radio, or television communication in interstate or foreign commerce any writings, signs, signals, pictures, or sounds for the purpose of executing such scheme or artifice shall be fined under this title or imprisoned not more than 20 years or both." Pursuant to paragraph 2 of the Code of Ethics for Government Services, members are expected to uphold the laws and legal regulations of the United States and never be a party to their evasion. Members must also act in a manner that reflects creditably on the House pursuant to House Rule 23, Clause 1. C. Findings. As detailed above, there is substantial evidence that Representative Santos participated in and financially benefited from a fraudulent scheme involving Redstone. At least 3 individuals transferred funds to Redstone after being told the money would be used for political purposes, when in fact the funds were transferred to Representative Santos's personal accounts. Representative Santos furthered the scheme through lies and misrepresentations about the nature of his connection to Redstone, just as he had done with a predecessor company, Red Strategies. Representative Santos's fraudulent activities through Redstone were one of many ways he sought to exploit his campaign and the access to wealthy donors it afforded him for his own personal profit. These actions did not reflect creditably on the House and resulted in a failure by Representative Santos to uphold laws and regulations of the United States. Accordingly, the ISC found Representative Santos violated House Rule 23, Clause 1 and Paragraph 2 of the Code of Ethics for Government Services in connection with this conduct. 2. Willful and knowing financial disclosure violations. 1. Background. First as a candidate and then as a member, Representative Santos has been subject to statutory requirements to file FD statements since 2020. Despite this, Representative Santos has failed to file 2 of his required FD statements and made numerous errors and omissions in the 2 FD statements that he did file, one of which he filed over 3 months late. To date, he has not filed the necessary amendments or late disclosures for the relevant years. Committee staff has repeatedly informed Representative Santos and his counsel that he should make the necessary amendments and filings. Prior to his swearing-in, committee staff also advised his staff of the FD filing requirements and offered to meet with the congressman to discuss his business and other activities. Despite this outreach, Representative Santos did not meet with committee staff about his FD statements and has taken no steps to address the committee's concerns. In a recent interview, he cast himself as a victim, someone who was being held to a different standard and was never told by the committee to correct his FD filings. This is just another fraud on the electorate. Representative Santos, through counsel, told the ISC that a professional tax preparer assisted with his FD statements from 2020 to 2022. The tax preparer that Representative Santos identified, however, denied assisting with any FD statements and informed the ISC she, quote, did no work for Representative Santos other than tax filings, end quote, from 2018 to 2019. In fact, there is no evidence that anyone assisted Representative Santos with his FD statements. Records from the online disclosure system indicate that it was Representative Santos himself who filed his 2020 and 2022 statements. Even if he had received assistance from the tax preparer or any other individual, all filers are personally required to certify that FD statements submitted to the House are, quote, true, complete, and correct to the best of my knowledge and belief, end quote. Representative Santos provided only limited information about his finances to the ISC, including copies of tax returns prepared for him for fiscal years 2020 and 2021. Those returns were prepared approximately 2 weeks after the ISC sent its RFI, and it is not clear whether Representative Santos has paid the more than $25,000 in taxes he owed at that time. Representative Santos also told the ISC that he was the vice president of Linkbridge Investors from August 2017 through January 2020 and worked for a Florida-based internet marketing company, Harbor City Capital, from July 2020 through April 2021. According to his response to the ISC, the only other position he has held since he first became a candidate for Congress was sole proprietor, DeVolder Organization, LLC. The DeVolder Organization is at the center of much of Representative Santos's fictional financial narrative. He has described it as his family's firm, both on his campaign website and to members of his campaign staff. The company was not, however, an established investment fund or wealth management vehicle for the DeVolder family fortune, as Representative Santos seemed to imply. Representative Santos formed DeVolder Organization, LLC, a Florida limited liability company, of which he is the sole owner, in May 2021. DeVolder Organization was listed as one of several Florida corporations to form the political consulting firm Red Strategies, which was also established in May 2021 and was dissolved in September 2022. Additionally, Representative Santos, through DeVolder Organization, had an ownership interest in the company Redstone. Redstone was formed in Florida on November 1, 2021, and was dissolved on January 25, 2023. The devolder organization was listed as party to several business dealings with individuals who also happened to be major campaign contributors. The earliest any of those deals appears to have even been contemplated was in early 2022, nearly a year after devolder organization was formed, when Representative Santos met with executives of a large insurance company affiliated with donors to his campaign. He was ultimately involved in introducing the executives to another campaign donor in the insurance industry and received a commission in December 2022 following the large insurance company's acquisition of the other business. The earliest payment Representative Santos seems to have received for his consulting work through devolder organization was only a few months prior in early October 2022. In fact, other than these two payments, all of devolder organizations reported consulting income in 2021 and 2022 appears to have come from either cash deposits or transfers from other bank accounts controlled by or accessible to Representative Santos, such as Devolder Santos for Congress and Redstone. The ISC's record tells a story of Representative Santos's personal finances that is drastically different from what he disclosed on his FD statements and even more irreconcilable with the narrative he broadcast to his constituents, campaign supporters, and staff. Several witnesses told the ISC how Representative Santos would boast of significant wealth and claim to have access to a trust managed by a family firm. In contrast, Representative Santos was frequently in debt, had an abysmal credit score, and relied on an ever-growing wallet of high-interest credit cards to fund his luxury spending habits. He occasionally deposited large amounts of cash that he has never accounted for, moved money between his various bank accounts in a highly suspicious manner, and made over $240,000 cash withdrawals for unknown purposes. Throughout both of his campaigns, Representative Santos referenced a background in finance as part of his qualifications for election to the House. That background was largely fictional. Representative Santos sold himself as a candidate based on that fiction. In one 2020 candidate survey, he claimed, quote, "I have an extensive background in money management, growth, and I'm good at it. I believe I can bring my expertise to the House and help create a balance on costs and balancing budgets," end quote. And in 2022, he asserted on the survey that he wanted to serve on the House Financial Services Committee, quote, "Because of my experience in the finance world, this is where I would be able to best serve my constituents and the country," end quote. Had Representative Santos filed accurate and complete FD statements, his constituents may have had cause to question whether he was actually good at money management and growth, or balancing costs and budgets, or indeed whether he had any experience in finance at all. A. 2020 FD Statement Errors and Omissions. Representative Santos first ran for Congress in 2020. On May 11, 2020, Representative Santos filed the FD statement required of candidates who raise or spend more than $5,000 in a campaign for election to the House. The 2020 FD statement was certified by Representative Santos as, quote, "true, complete, and correct to the best of my knowledge and belief," end quote. Representative Santos reported no assets, and the only income he reported was his receipt of a, quote, "salary, commission, and bonus of $55,000 from Linkbridge investors for calendar year 2019, end quote. He listed his income from Linkbridge as NA for 2020 and listed an unquantified commission bonus from Linkbridge in the section of the FD statement that requires disclosure of compensation in excess of $5,000 received from a single source for the filing year and 2 preceding calendar years. While the modest income indicated on the 2020 FD statement was far closer to the truth than the story he was weaving during his campaign, the filing still did not accurately reflect Representative Santos's actual finances. Representative Santos did not provide his 2019 tax return and related underlying documents to the ISC. His counsel asserted early in the ISC's investigation that this was because his, quote, 2019 taxes filings are not in his possession, end quote. But Representative Santos failed to obtain and produce those records, which would be available to him through the IRS at any point during the ISC's review. Nonetheless, the ISC obtained documents showing Representative Santos made only $27,555 from Linkbridge investors in 2019. Representative Santos did not disclose his income from Harbor City Capital or his position with the company during the reporting period. Representative Santos has not provided any explanation for why he failed to accurately report his income on the 2020 FD statement. In 2 credit card applications submitted in May 2020, including one submitted the same day as his FD statement, Representative Santos listed his annual income as $85,000. In an attempt to write off concerns related to his income discrepancies, Representative Santos stated in a May 10, 2023 interview with MSNBC, "So, the way I look at it is, they're not understanding. The question is simple. George, why was your income $55,000 in 2020? And why is your income drastically higher in 2022? Well, here's the answer to that. We struck a deal with a company, so nobody went unemployed and got reduced to like a very basic salary. As we called it, livable wages in the company so we could get by. Because our industry was capital introduction via vis-a-vis conferences, vis-a-vis speed dating, all that in private equity, and managing limited partner, general partner relationships in investment groups. So, long story short, I went from 2019 bringing in $400 and something thousand to, in 2020 my reported income was $55K. Couldn't be more legitimate. I actually qualified for unemployment. However, based on the ISC's review of his bank accounts, there is no record of him earning income over $400,000 for the year 2019, nor has he provided evidence of any investments or assets he held in 2019 to 2020. B. Failure to file 2021 FD statement and confrontation with campaign staff over FD issues. Representative Santos launched another campaign for Congress for the 2022 election. Representative Santos qualified as a candidate as early as January 15, 2021. He was required to file an FD statement by May 15, 2021, disclosing his financial information for the prior calendar year through a date within 30 days prior to the date of filing. He did not do so. In response to the ISC's March 10, 2023 RFI, Representative Santos produced tax returns for 2020 and 2021 that are dated as having been prepared March 23, 2023, and include his 2023 address. The 2020 return and related documents show that Representative Santos reported $91,379 in total income to the IRS for calendar year 2020, including $79,019 in business income and $22,560 in unemployment compensation. He listed his profession as consulting and his business as DeVolder Organization, even though DeVolder Organization LLC did not exist until May 10, 2021, after the tax reporting period covered by the return. He did not disclose the $34,230.62 in income he received from Harbor City Capital that year, for which he had been provided a Form 1099. It is not clear why that 1099 income is not disclosed on the relevant line of his 2021 tax return, since he provided a copy of the Form 1099 to the ISC the day after the returns were filed. In addition to disclosing his income, Representative Santos was required to disclose his position with Harbor City Capital. Representative Santos has not provided any information about why he failed to file his FD statement with the House in 2021, but the ISC received evidence that he was concerned about the potential political impact of his involvement with Harbor City Capital, which was the subject of an SEC enforcement action announced in April 2021. One of Representative Santos's campaign consultants testified that, as early as November 2021, she explicitly discussed the required 2021 FD statement with Representative Santos, who told her, quote, "It's handled," end quote. Additionally, in December 2021, Representative Santos's campaign consultants confronted him about an internal vulnerability report that highlighted the inconsistencies between his 2020 filing and his public pronouncements of wealth, as well as his complete failure to make the required filing for 2021. Representative Santos's campaign consultant sent him a brief summary of, quote, "potential attacks," end quote, at his request, highlighting that his, quote, "personal financial disclosure, or lack thereof, was a massive problem," end quote, for several reasons. Quote, "Even if, when you go back and amend past reports or file new disclosures this cycle, it looks as if you are hiding assets. 2. While you believe it is fine to keep assets under a trust, your lifestyle, heavily documented on social media, real estate holding, campaign contributions, etc., portray a very different reality. This adds to the fraud narrative. 3. There is a very likely chance you will be targeted by the IRS for a personal financial audit. And 4. While you are not directly implicated in any of your former employer's legal and criminal complaints, the fact that you have a pattern for working with 4 employers who have all come under legal and financial scrutiny adds to the fraud narrative." End quote. In response to concerns raised by his campaign consultants, Representative Santos denied the findings in the vulnerability study, and for every concern raised, he made an excuse. He told one of the campaign consultants that his sparse 2020 FD statement could be reconciled with his claims of wealth because he did not need to disclose a family trust. The ISC found no evidence that such a trust exists. C. 2022 FD statement errors and omissions. As a candidate in the 2022 election, Representative Santos was also required to file an FD statement by May 15, 2022. This FD statement was certified by Representative Santos as, quote, "true, complete, and correct to the best of my knowledge and belief," end quote. Representative Santos filed his FD statement over 3 months late, on September 6, 2022. He did not request a filing extension for his 2022 FD statement, and he has not addressed why this report was filed late. The committee has no record of him paying the required late filing fee. Representative Santos reported 4 assets. 1. An apartment in Rio de Janeiro, Brazil, valued between $500,001 and $1 million. 2. A checking account with between $100,001 and $250,000. 3. A savings account with between $1,001 and $5 million, and 4. 100% ownership of DeVolder Organization, valued between $1,001 and $5 million, with dividends of over $1,001 in both 2021 and 2022. Each of these disclosures was false. As Representative Santos informed the committee through his counsel, he, quote, "does not and has never owned real property," end quote. He had not disclosed any real property on his prior FD statement and has provided no explanation for why it was included on his 2022 FD statement. However, the ISC received testimony from several witnesses indicating that Representative Santos commonly claimed to own property, not just in Brazil, but also in New York and Florida. During his 2022 campaign, Representative Santos claimed to own 13 rental properties and discussed how the pandemic-era eviction moratorium affected him as a landlord. With respect to the checking and savings accounts disclosed by Representative Santos, the committee found no record of him having a savings account or any personal bank account that ever had more than $100,000, let alone more than $1 million, at any time as of the date of his 2022 FD filing. At the start of the date of his filing, the balance in his primary savings account was $6,692.23. By the end of that day, it was down to $3,068.63 after a rent check he had written a few days before was processed. His primary checking account had a beginning balance of $1,579.18. By the end of the day, it was down to $35.15 after several personal credit card accounts were paid. Likewise, defaulter organizations' bank accounts never amassed a value of over $1,001, let alone net income remotely close to this amount. In May 2021, Representative Santos also opened an account for defaulter organization at a major bank with ATM locations in Long Island, New York. On the business deposit account application, he described defaulter organization as a political consulting firm with an annual gross revenue of $1,500,000 and an annual net profit of $800,000. He listed his email as george.devolder@redstrategies.com. See. He listed the source of funds used to start the business as $10,000 of lifetime savings and indicated the business would receive income primarily in the form of consulting fees. Representative Santos's use of both his business and personal accounts with this bank seemed to primarily be to deposit and then withdraw funds, often at ATMs and/or in all-cash transactions. The source for the significant cash deposits, which were often made just before a withdrawal for a similar amount, remains unclear. Defaulter organization only came into existence in mid-2021 and had no substantial financial activity at the time of Representative Santos's 2022 filing. The company's 2021 profit and loss statements indicate an income of $614, with more than $14,000 in expenses, for a total loss of more than $13,000, and it was not until after the FD statement was filed that defaulter organization made any substantial income. On the date of the filing, September 6, 2022, defaulter organization had $4.08 in its bank account. As previously noted, Representative Santos recently filed a late tax return with the IRS for 2021. In the return, Representative Santos reported a negative $70,481 in total income, comprised of a $90,785 business loss from defaulter organization and $20,304 in unemployment compensation. The defaulter organization income reported on his tax return for 2021 bears no relationship to the company's actual finances for 2021. The loss was reported as being primarily due to contract labor costs, which Representative Santos reported as consisting of a $17,000 payment to a company owned by one of his campaign consultants and two payments totaling $138,000 to individuals involved in an insurance deal. However, all of those payments occurred in 2022, not 2021. Representative Santos failed to disclose his unemployment income as well as his income from Harbor City Capital. On multiple credit card applications filed throughout 2021, Representative Santos stated his income was $9,000 per month or $108,000 annually. Furthermore, Representative Santos failed to report unearned income on his FD statement from other assets, including over $20,000 in stock transactions from 2021. Additionally, although Representative Santos did disclose his position as managing principal of defaulter organization, he failed to disclose his position as regional director of Harbor City Capital, as well as his partnerships through defaulter organization with Red Strategies or Redstone and unearned income from these companies. Representative Santos disclosed only one liability: a car loan valued between $15,001 and $50,000 with Westlake Financial incurred in 2021. He indicated on the disclosure that the car loan was a joint liability. Representative Santos did not produce the loan documentation, but did provide a screenshot from the lender's website indicating that payments were made on a 2015 Mercedes-Benz vehicle from May 12, 2021 to March 12, 2023. Bank records reviewed by the committee confirm that Representative Santos made those payments through a personal bank account. At no point does Representative Santos appear to have owned a Maserati, despite telling campaign staff otherwise. D. Failure to file 2023 FD statement. Representative Santos was granted an extension to file his 2023 FD statement through August 13, 2023, but did not meet the extended filing deadline. On September 13, 2023, the committee's Financial Disclosure Office sent Representative Santos a letter informing him that he had not timely filed his FD statement and owed a $200 late filing fee. The same day, Representative Santos's counsel informed the ISC that, quote, Representative Santos and his accountant have not yet completed his 2022 tax returns, and therefore Representative Santos will be unable to make the filing deadline for his House disclosures. I will keep the committee updated as to the status of these filings, end quote. The committee sent 2 additional letters on September 27th and October 20th, 2023, informing Representative Santos that, quote, continued failure to file your FD statement could be deemed willful noncompliance, and encouraging him to file his 2023 FD statement immediately. The October 20th letter was deemed a final notice that if his 2023 FD statement was not filed by October 27, 2023, the committee would, quote, take action not inconsistent with Section 104 of the Ethics in Government Act as it deems appropriate, end quote. On October 24, 2023, Counsel informed the ISC that Representative Santos paid the $200 late filing fee and would be filing his 2023 FD statement, which Representative Santos has still failed to do. Additionally, Representative Santos and his current and prior counsel were repeatedly reminded by the ISC that, to the extent the Congressman was or became aware of any errors or omissions on prior FD statements, he should file amendments to those statements, including in its March 10, 2023 RFI, in correspondence with the member on May 31, 2023, in correspondence with counsel on April 19, 2023, May 17, 2023, June 22, 2023, and September 11, 2023. And in calls with counsel on July 6, 2023 and September 6, 2023. Representative Santos has not amended his prior statements despite the significant errors and omissions discussed above. 2. Relevant laws, rules, and other applicable standards of conduct. Title I of the Ethics in Government Act, EIGA, requires annual financial disclosures by members of the House, candidates for the House, and senior House employees. Members and qualifying candidates must annually disclose personal financial interests, including investments, income, and liabilities. EIGA requires financial disclosure reports to include, quote, the source, type, and amount or value of income, end quote, quote, the source and type of income which consists of dividends, rents, interest, and capital gains, end quote, over $200, quote, a brief description, the date and category of value of any purchase, sale, or exchange during the preceding calendar year which exceeds $1,000 A in real property, other than property used solely as a personal residence of the reporting, B, in stocks, bonds, commodities, futures, and other forms of securities, end quote. Quote, the identity of all positions held on or before the date of filing during the current calendar year, end quote, and, quote, the identity of each source of, end quote, and, quote, a brief description of the nature of the duties performed or services rendered, end quote, for, quote, individual compensation in excess of $5,000, end quote. House Rule 26 adopts Title I of EIGA as a rule of the House. EIGA also identifies the committee as the supervising ethics office for House members and candidates with respect to the implementation of the financial disclosure requirements. As the Commission on Administrative Review of the 95th Congress stated in recommending broader financial disclosure requirements, quote, "The objectives of financial disclosure are to inform the public about the financial interests of government officials in order to increase public confidence in the integrity of government and to deter potential conflicts of interest." End quote. Violations of the laws governing House FD statements may implicate House Rule 28, Clauses 1 and 2, which state, quote, "A member of the House shall behave at all times in a manner that shall reflect creditably on the House, and, quote, shall adhere to the spirit and the letter of the rules of the House." End quote. The committee has previously noted that inadvertent errors in FD statements are common, and absent evidence that errors or omissions are knowing and willful, the committee's general practice is to notify the filer of the error and require an amendment. However, if a filer knowingly and willfully falsifies or fails to file or to report any required information, the committee may take appropriate action, including referring the filer to the Attorney General, pursuant to Section 13106 of the EIGA. This section further states that, quote, "The Attorney General may bring a civil action against any individual who knowingly and willfully falsifies or who knowingly and willfully fails to file or report any information that such information is required to report," end quote, and can impose a civil penalty of up to $71,316. In addition to enforcing the financial disclosure requirements of EIGA and related House rules, the committee has also investigated and disciplined members in connection with their failure to properly report and pay taxes. The committee has noted that failure to comply with tax laws and regulations is inconsistent with Clause 2 of the Code of Ethics for Government Service, which provides that any person in government service should, quote, "uphold the Constitution, laws, and legal regulations of the United States and of all governments therein, and never be a party to their evasion." End quote. 3. Findings. Based on the record discussed above, there is substantial reason to believe Representative Santos knowingly and willfully failed to properly disclose required information on FD statements filed with the House, in violation of the EIGA, House Rule 26, and House Rule 28, Clauses 1 and 2. In his first campaign for Congress, Representative Santos filed an FD statement that was rife with missing and inaccurate information. Representative Santos then failed to file his 2021 FD statement in its entirety, despite being aware of the requirement that candidates must file FD statements, a requirement with which he had previously at least attempted to comply. Even after his campaign consultants flagged the issue for him later in 2021, he still failed to make the required filing. In 2022, his FD statement was even more egregiously riddled with errors, omissions, and misleading information intended to make him appear more successful and wealthier than he was in reality. Most disturbingly, as a sitting member of Congress, he has continued to flout his statutory obligation to file an FD statement for the current year, despite the committee and his personal staff having advised him of the statutory requirements and widespread attention to his lack of transparency regarding his financial situation. These were not inadvertent lapses, but major errors and omissions, and the evidence compiled by the ISC demonstrates that they were knowing and willful actions as part of an ongoing ruse by Representative Santos to fabricate a wealthy persona, even after he was repeatedly put on notice of the failures and falsehoods relating to his required FD statements. Representative Santos has shown no effort to amend the errors and omissions in his prior disclosures, despite receiving multiple instructions from the committee and the ISC to do so. Indeed, despite the myriad excuses communicated through counsel, neither Representative Santos nor any individual authorized to assist him with his FD statements has logged into the House Financial Disclosure System since his extension request was filed in May 2023. The ISC further notes that, Pursuant to Section 13106 of EIGA, the committee is required to refer Representative Santos to the Attorney General if it has reason to believe he has willfully failed to file a report or has willfully falsified or failed to file required information. As discussed above, Representative Santos has been duly warned of the committee's obligation to make such a referral, and by this report, the ISC now recommends that the committee refer this matter to the Attorney General. 3. Lack of diligence and candor during the ISC investigation. 1. Background. Shortly after the committee announced that it had impaneled an ISC to review allegations relating to Representative Santos, he told news outlets, quote, "I'm going to comply 100% with the committee's investigation," end quote. His cooperation fell well short of his stated intention. On March 10, 2023, the ISC sent an RFI to Representative Santos seeking information related to the allegations under review. Despite his public assurances, Representative Santos provided limited documents to the ISC, often following lengthy delays. Representative Santos's counsel offered various reasons for the delays: withdrawal of prior counsel in May 2023, the need to work with a third-party vendor to analyze and organize the materials, multiple personal and other client matters that arose, the ongoing criminal investigation, and that certain documents, such as tax returns, were purportedly outside of Representative Santos's custody and control. While it is not uncommon for respondents to require additional time to gather information to respond to requests from the committee, it is clear to the ISC that Representative Santos's claim that he would cooperate with the investigation was just another falsehood. The number and nature of the excuses provided by Representative Santos's counsel, coupled with the absence of a meaningful response from Representative Santos to the ISC's RFI that was issued over 8 months ago, evidenced a lack of diligence and sufficient respect for the committee's investigative process. In July, after months had passed without any new documents being produced, the ISC pressed Representative Santos's counsel to respond to its document requests. At the time, counsel assured that documents would be provided on a rolling basis and that documents were in the process of being reviewed and collected. However, no documents were provided to the ISC until September. That production, which was not complete, consisted of documents that had been previously produced to the federal grand jury but were inexplicably withheld from the ISC for over 5 months. Shortly after this production, and after having produced no documents specifically responding to the ISC's RFI since April, counsel informed the ISC that, quote, "We are not obstructing the work of the committee," end quote, and that the ISC could expect, quote, "a substantial amount of new responsive documents," end quote, within 3 days of that correspondence. No such documents were produced. The next production the ISC received occurred on November 2, 2023, consisting of 5 pages of select email communications Representative Santos's counsel had provided to DOJ weeks prior. To date, Representative Santos has not provided a substantive production in response to the ISC's request for his communications with Ms. Marks or other members of his campaign staff during his 2020 and 2022 campaigns. While he has delayed providing the ISC with all of his communications during the campaign, he has simultaneously blamed Ms. Marks for some of the most serious campaign finance allegations. As noted previously, however, the ISC's record showed that concerns about Ms. Marks were brought to Representative Santos during both his 2020 and 2022 campaigns. He was aware of how she was reporting personal loans. He was actively involved in the campaign's day-to-day finances, and Ms. Marks has testified that Representative Santos was an active participant in devising a fraudulent scheme to falsify reports to the FEC. As with all respondents to a committee investigation, the ISC requested that Representative Santos submit a declaration attesting under penalty of perjury to the accuracy of any information submitted in writing by someone other than himself, such as letters from his counsel. Representative Santos did not do so. He has also declined to voluntarily testify before the ISC. The limited substantive information that has been provided to the ISC has come through Representative Santos's attorneys. Even absent a signed declaration, Representative Santos is responsible for ensuring that his representatives make truthful and accurate statements on his behalf, and efforts to mislead the ISC by supplying his attorneys with false information or half-truths may be considered obstructive conduct. In addition to his claims about Ms. Marks, several responses that Representative Santos provided the ISC through his counsel were not supported by the evidence the ISC collected from other sources. For example, in response to the ISC's request that Representative Santos inform it of the names of any individuals who assisted him in the preparation of his FD statements, Representative Santos's counsel advised that his tax preparer assisted him, but provided no documents to support that contention. The tax preparer advised the ISC that she did not provide those services, and in fact, Representative Santos appears to have submitted the FD statements on his own. Representative Santos was also advised on multiple occasions to correct errors and omissions in his FD statements and to file his FD statement for the current year, and failed to do either. On October 24, 2023, his counsel assured the ISC that Representative Santos, quote, should have his 2023 FD filing submitted shortly, end quote. He is currently the only member of Congress who has failed to do so. Representative Santos has not only refused to provide requested documents and sit for a voluntary interview, he has failed to address most of the allegations under review by the ISC in any way beyond pointing a finger at his treasurer and denying any wrongdoing. Despite rebuffing the ISC, he has done multiple press interviews regarding the allegations, each rife with statement that the ISC's record reveals to be untrue. Representative Santos did provide a substantive and relatively prompt document production in response to allegations of sexual misconduct raised by a prospective staffer. In addition, current members of his congressional staff participated in voluntary interviews and denied that Representative Santos tried to dissuade them from cooperating. The ISC appreciates Representative Santos's diligence in responding to the sexual misconduct allegation and his congressional staff's cooperation, but his ability to provide a robust response to the sexual misconduct allegations while failing to provide similar responses to the ISC's campaign and financial disclosure-related inquiries suggests that his willingness to comply with the ISC's processes turned on whether he believed doing so was in his personal interest, rather than fulfilling his duty to cooperate with the ISC's investigation and facing accountability through the House's disciplinary process. 2. Relevant laws, rules, and other standards of conduct. The committee has explained that it expects members, delegates, and staff to honor their duty of candor and diligence in participating in the committee's investigative process. The committee has previously stated, public office is a trust, and as part of that public trust, public officials should take seriously allegations that threaten the integrity of the institution and seek to be forthright and cooperative with the body designed to review such allegations. It is the nature of a self-regulatory body to strive to collegially review allegations of misconduct and, accordingly, the committee's long-standing practice is to seek voluntary cooperation from respondents. When that cooperation is less than fulsome, that threatens to undermine the foundations of that self-regulation. In past matters where members have refused to diligently respond to committee requests and/or have engaged in conduct that interfered with or obstructed the committee's investigation, the committee has found such conduct to be the basis for a violation of the Code of Official Conduct. Additionally, federal law makes it a crime to falsify, conceal, or cover up a material fact in a committee investigation, or to corruptly influence, obstruct, or impede a congressional proceeding. 3. Findings. The ISC found that Representative Santos's conduct in connection with its investigation violated House Rule 23, Clauses 1 and 2. All respondents are entitled to invoke their constitutional rights, but they are not entitled to provide misleading responses and engage in delay tactics. The ISC recognizes that the responses it received from Representative Santos came from his counsel, and he never signed a declaration, as requested. Even if that means his statements cannot be considered under 18 U.S.C. sections 1001 and 1505, he is responsible for providing truthful information to the committee. Representative Santos has also misled the public in promising to cooperate with the committee when his own actions show his intent was just the opposite. Far from fully cooperating, the false or misleading submissions from his counsel, as well as the substantial delays to the ISC's investigation, show that Representative Santos has not been acting in accordance with his duty of diligence and candor. His conduct in this investigation is therefore not consistent with the requirement that members act in a manner that reflects creditably upon the House and adhere to both the spirit and the letter of the rules. C. Other allegations reviewed by the subcommittee. 1. Sexual misconduct allegation. The ISC reviewed an allegation that Representative Santos may have engaged in sexual misconduct towards an individual seeking employment in his congressional office. OCE also referred this allegation to the committee with a recommendation that the committee dismiss the allegation, finding that there was not substantial reason to believe that Representative Santos sexually harassed or discriminated against Witness 10, a prospective employee. Witness 10 was brought to the attention of Representative Santos's office in mid-January 2023 by Witness 8, as the office was looking for a staff assistant. Witness 10 made 7 payments totaling $1,050 to Witness 8 that month, 2 of which were made the day he received an offer of employment from the congressman's office. On January 25, 2023, Witness 10 was asked to come to the office to meet other members of staff. He returned to the office on several other occasions for varying amounts of time, but was later instructed not to return until he was cleared by Human Resources and could be onboarded. However, on February 1, 2023, his offer of employment was rescinded due to the office's concerns about then-pending felony wiretapping charges against him. 2 days later, Witness 10 filed a complaint with the committee alleging that Representative Santos engaged in sexual misconduct towards him while they were alone in the congressman's office on January 25, 2023, quote, going over mail correspondence from constituents, end quote. The ISC was unable to substantiate this allegation. Testimony from witnesses contradicted Witness 10's testimony about reviewing mail with the congressman and being alone with him in his office. The ISC also had concerns about Witness 10's credibility and motivation in making the allegation, based on other evidence reviewed during the investigation. For example, the ISC noted inconsistencies in Witness 10's testimony, and he stated that he contacted the Federal Bureau of Investigation with his allegation in order to be paid by them for information regarding Representative Santos. 2. Conflicts of interest. 1. Devolder Organization. As discussed previously, Representative Santos is the sole owner of the company Devolder Organization. According to the Florida Department of State, the Devolder Organization filed an annual report on January 11, 2023, over a week after Representative Santos took office, and its status is still listed as active. Committee staff advised Representative Santos's counsel that, to the extent Representative Santos has taken steps to wind down his business, he should provide that information and any supporting documentation to the ISC. Other than bank statements showing that Representative Santos closed the Devolder Organization account on January 26, 2023, the ISC received no further information related to winding down a Devolder Organization, and it retains an active registration. Section 13144 of the EIGA prohibits a member from, quote, receiving compensation for affiliating with or being employed by a firm, partnership, association, corporation, or other entity which provides professional services involving a fiduciary relationship, end quote, and from, quote, permitting the member's name to be used by a firm, partnership, association, corporation, or other entity that provides professional services involving a fiduciary relationship, end quote. House Rule 25, Clause 2A mirrors this language. Because Representative Santos has not meaningfully cooperated with the ISC's review, the ISC was unable to determine whether the Volder organization has provided fiduciary services since Representative Santos began serving in Congress. 2. Criminal Attorney. Representative Santos's current counsel before the ISC, Joseph W. Murray, also represents him in the federal prosecution. DOJ filed a motion seeking a hearing to determine whether there was a conflict of interest involving Mr. Murray, quote, arising from relationships that counsel has with two individuals who are referenced in the superseding indictment, namely person number 1 and Nancy Marks, end quote. Specifically, these conflicts relate to Mr. Murray's personal relationship with person number 1 arising from their mutual involvement in local politics, person number 1's having sought Mr. Murray as counsel to represent him during DOJ's investigation that included an initial consultation, including discussion of the investigation, and Mr. Murray's professional relationship with Ms. Marks, who served as his campaign treasurer during his campaign to become the Queens County District Attorney in 2019. Through the course of its investigation, the ISC learned that Mr. Murray also has a personal and professional relationship with an individual working in Representative Santos's congressional office. This individual was the office manager of Mr. Murray's law firm while also serving as a constituent services representative in the district office. One staffer indicated that Representative Santos said he knew this individual and was very insistent on bringing her on board. She received a congressional salary of $10,999.99 from January 19, 2023 through March 31, 2023, and $16,250.01 from April 1, 2023 through June 30, 2023. The ISC received testimony that she, quote, seemed to do a good job at her job, end quote, and that her supervisor never raised any complaints about her job performance. The ISC did not receive any information about whether the individual's employment was intended as some form of compensation for Representative Santos's counsel's criminal defense services, or whether the individual has used any official resources in connection with Representative Santos's personal legal defense. 3. Additional allegations charged by the Department of Justice. The ISC also considered the additional charges raised in the federal indictment of Representative Santos, such as whether Representative Santos misused credit card information, but was limited in the extent to which it was able to review certain charges due to DOJ's request that the ISC defer taking certain investigative actions. The ISC similarly considered whether Representative Santos was aware of or otherwise involved in efforts by a member of his campaign team, Individual 5, to solicit contributions on behalf of his campaign by impersonating a staffer in then-Leader McCarthy's office, conduct which was the subject of charges filed against Individual 5, but not Representative Santos himself. Due to DOJ's specific deferral requests and a witness's invocation of the Fifth Amendment, the ISC was unable to fully investigate this allegation. However, other campaign staff testified that Representative Santos was reluctant to terminate Individual 5 after learning of the allegations. Although Individual 5 was eventually fired from Representative Santos's campaign in late 2021, the staffer appeared to remain in Representative Santos's political orbit. As the state political committee Representative Santos helped run reported paying Individual 5's firm as late as June 2022. 4. Recommendations to committee. Under committee rules, an ISC has two options at the conclusion of its review. It may adopt a Statement of Alleged Violation, SAV, which is a prerequisite for an adjudicatory subcommittee and recommendation by the committee for a sanction by the House. An ISC may also choose not to adopt an SAV. If the ISC does not adopt an SAV, it must transmit a report to the committee summarizing the evidence received, the ISC's findings, and any recommendations. The ISC's recommendations may include a letter of reproval and/or that substantial evidence of a violation of law be referred to appropriate federal or state authorities. The committee has a long history of disciplining members for the types of misconduct at issue here. A member who, among other allegations, reported a fictitious campaign loan to inflate his cash on hand was reprimanded and fined by the House. Other members who were found to have engaged in intentional circumvention of campaign finance laws were the subject of significant charges of violations by the committee, as well as various sanctions. The House has previously reprimanded a member for making false statements on FD forms. In another matter, the committee sanctioned a senior House staffer who was found to have failed to report income on FD forms and federal tax returns. Members who have been found to engage in obstructive or bad faith conduct in connection with committee investigations have been reprimanded by the House, reproved, and referred to DOJ. In many instances where members have engaged in significant criminal activity, they have resigned from the House. This matter, however, is unprecedented in many respects. First, it has been the subject of member complaints, House resolutions, an OCE referral, an FEC matter, and federal criminal prosecution. As such, the integrity of the House has been called into question in a significant and overt manner that the committee cannot ignore. Second, while it is not uncommon for committee investigations to involve multiple allegations and a pattern of misconduct, the sheer scope of the violations at issue here is highly unusual and damning. Third, the nature of the violations are fundamental ethical failings that go to the core of the legitimacy of the electoral process. And most significantly, Representative Santos's fraud on the electorate is ongoing. He continues to propound falsehoods and misrepresentations rather than take responsibility for his actions. The ISC unanimously determined that the committee's duty to safeguard the integrity of the House and the interests of justice warranted the immediate disclosure of its findings. Although the ISC's findings of serious and pervasive campaign finance violations and fraudulent activity would merit the adoption of an SAV, proceeding down that path would risk substantially interfering with DOJ's ongoing and active investigation of Representative Santos for similar allegations, and would not be an efficient use of the committee's resources, particularly in light of the congressman's penchant for obfuscation and delay. Representative Santos declined nearly every opportunity he was afforded under the committee's processes to provide a rebuttal to the allegations, and his general attempts to blame his former campaign treasurer, or feign ignorance, or misreporting were not supported by the evidence. Representative Santos is entitled to due process in his criminal prosecution, and will have his day in court. As a member of the House, however, he must be held accountable to the highest standards of conduct in order to safeguard the public's faith in this institution. The Constitution charges the House with policing the behavior of its own members, and the House should take whatever action it deems appropriate in light of the ISC's findings. Accordingly, pursuant to Committee Rule 19G, the Investigative Subcommittee makes the following recommendations. 1. The ISC recommends that the committee immediately refer to the U.S. Department of Justice for such action as DOJ deems necessary, the matter involving Representative Santos regarding his knowingly causing his campaign committee to file false or incomplete reports with the Federal Election Commission, use of campaign funds for personal purposes, fraudulent conduct in connection with Redstone Strategies, LLC, and knowing and willful violations of the Ethics in Government Act as it relates to his financial disclosure statements filed with the House. 2. The ISC recommends that the committee authorize the release of materials in possession of the committee and not available through any other source to the U.S. Department of Justice, as necessary for any further action DOJ pursues as a result of the referral of this matter. 3. The ISC recommends that the committee adopt this report and publicly condemn Representative Santos, whose conduct the ISC found to be beneath the dignity of the office and to have brought severe discredit upon the House. This concludes this episode of The Docket. I hope you enjoyed this episode. For updates on The Docket, please visit docketpod.com or find us on Threads as DocketPod. If you found this useful or interesting, please consider subscribing to the Docket and supporting my Patreon at patreon.com/docketpod. Thank you.